you. Now, we're going to slightly broaden the debate now, and we have, as part of our panel discussion, Mike Allen from Focus Ireland and Rossa Fanning, again, a barrister. So, again, could we start maybe with about a 3-minute intervention on either of your sides?
Okay. Just from here?
Yeah, if you like, yeah.
My name's Mike Allen. I'm the Director of Advocacy in Focus Ireland, which is one of Ireland's leading homeless and housing organisations. And since it was founded in 1985, we have argued that everybody should have a right to a place that they can call home. So we've seen rights as fundamental from the very beginning. We now understand that right to a home or right to housing as part of a broader range of economic and social cultural rights you're discussing today. I'm amongst those who think this is a complicated issue and that it's very hard to discuss because of the range of issues that are involved. And what I hope to bring, by what I say now and what maybe the questions that arise, is the specificity about what we believe this might mean in relation to the issue of housing, not just homelessness, but including homelessness. And broadly, what we think the difference it makes is, one, in terms of the framework that it sets, that it set it by establishing the view that we believe as a society that the right to have a house, the right to have adequate accommodation is central to the way we want to see our country to evolve. That will guide our legislators, and it will also guide the way that we actually undertake practice at the moment. We also think it's extremely important to drive this discussion, that to have a discussion here about the right to a home and a right to a house, as opposed to the discussion we've had for the last 15 years about the value of your house as if it were just a commodity. And it is about that discussion that this society is crying out for, about our values and the way that we want to go. And the last point I'd make, because I know it's just an introduction, is why we see this as important is because there has been huge political and commitment from the previous government and this government to do something about homelessness. But it has been done in a particular sort of way. While in Scotland, there has been an equally strong drive, except it's been underpinned by a right to a home. And any comparison between what's been achieved in Scotland and achieved in Ireland over that period of time shows that the Scottish system of dealing with homelessness and housing has been more effective. It hasn't cost more money to have a right to housing. It has cost less money, and it has led to fewer people on the streets. So it's both a values argument and a practical argument that we're supporting. It's specifically the right to housing being in the Constitution, but that should be seen in the broader context of economic, social, cultural rights.
Thank you very much, Mike, for such a pithy contribution. Rossa, would you like to comment on whatever issue you want to make in support of the case Michael has made?
Thank you very much, Mr. Chairman. By way of introduction, I think the point I'd like to begin by making is that there's a real danger of having this debate in a sort of fantasy world where the debate is taking place in some sort of vacuum, completely divorced from the economic circumstances in which the country finds itself. It sort of sometimes seems like if Carlsberg did constitutions, they would have one replete with socio-economic rights. That may be so, but the fundamental difficulty of all of this is defining socio-economic rights in such a way that does not undermine the fundamental role of government to define and determine difficult policy decisions in relation to public expenditure. Because the corollary of saying that one person has a right to something is saying that somebody else has an obligation to pay for it. These rights aren't free rights that can simply be identified and respected. Somebody actually has to pay for them. And to use a concrete example, because I do agree with Michael that you're better focusing on actual examples, if we say today that the right to free primary education, which is a constitutional right, must encompass the right to free textbooks. Is that textbooks or is it a laptop? If it's a laptop, is it a clunky Dell that really doesn't download things very fast anymore, or is it a top-of-the-market MacBook? Is the deprivation to somebody of not having a mobile phone or not having wireless internet at this stage in 2014 a deprivation of their rights? Can children really be properly educated anymore without access to the internet for any sort of a career? And these are real and reasonable questions in terms of the allocation of resources. But it's difficult to imagine, as Michael says, that the best party to determine the answer to the line between what is a constitutional right and what is a desirable political decision as to the allocation of a resource. It's difficult to imagine that the best person to determine that is a High Court judge. And this debate in modern times really began with the Sinnott case concerning the question of what specific rights Jamie Sinnott, a young autistic man, had under the bundle of constitutional rights that he and his mother were asserting on his behalf. It's all very well to say that an autistic person has constitutional rights, but does that mean 10 hours of one-to-one speech therapy per week? Does it mean 20 hours one-to-one speech therapy a week? Does it matter how much that costs? Because there is a platinum education service, there's a gold educational service, and there's a bronze one. One might cost $50,000 a year per student, one might cost $250,000 a year per student. So there are real judicial allocation, or real resource allocation decisions that have to be made. And the Sinnott case wasn't a standalone case. There were about 100 cases brought by autistic children a decade ago, seeking specific rights, not the recognition of a general right, but seeking High Court orders directing the Minister for Education to provide 20 hours individualised one-to-one speech therapy. And High Court judges were having to hear cases for 50 days with expert evidence as to what exactly was appropriate for the needs of an individual plaintiff. And that's the focus in the case of autism, which is but one of the many issues that could come before the court under this general area. And there is a real question, and I have to say I share Michael McDowell's scepticism, as to whether the High Court is the appropriate place to find the dividing lines between, on the one hand, what is a constitutional right, and what, on the other hand, is a resource allocation decision that's better left to the Oireachtas and the government, in turn, answerable to the Oireachtas for expenditure decisions.
Thank you very much, Rossa. Now, we have about 35 minutes left in this session, and I'd like to engage with you, the audience, and with the panel. And again, I'm going to do my best to ensure that there is an absolutely fair and equal allocation of time to the people on both sides of me. So, could we start with, are there any comments? And again, I will prefer to take, again, people who perhaps haven't spoken today yet, if possible. Ivana first. Yeah. And again, could I ask everybody to be quite brief and pithy?
Thank you, Chair. Ivana Bacik, and just to thank the presenters for very thought-provoking presentations. I do have a number of issues to take up with Michael McDowell, who, in his customary flair, I think did his best to make the issue sound perhaps unnecessarily complex. And I would just say that I think that some of the issues he's raised, perhaps unfairly represent the argument for inclusion of ESC rights. I mean, I would say, first of all, as Colm and Mary clearly put it, this is not, in fact, out of keeping with our tradition, our own constitutional tradition, because we do, of course, have very well-developed case law. In fact, Ross has just mentioned some of the case law on, for example, the right to education, which, of course, in the Sinnott case, the courts did, in fact, draw parameters around. They didn't engage in the sort of micromanagement that Michael and Rossa have suggested might be an outcome of inclusion of ESC rights. Rather, they set out the parameters. And I think all we're being asked to do here is to consider whether we want to include a set of rights in the Constitution that would set out the aspirations or the vision for a more equal society. We're not going to be asking the courts to allocate resources in particular cases. The how of that resource allocation remains a matter for elected representatives, and Mike is quite right about Article 6. But I don't believe that it's incompatible with expanding somewhat the range of rights that are currently injusticiable under our Constitution. We do have a text. We have Article 45, which could be updated and strengthened. We have the International Covenant, which we heard about earlier. And there's a well-accepted body of rights, which we could, as a constitutional convention, decide we want to see in our Constitution. We could say, at a minimum, we want to see the right to housing, to healthcare, to social security, to social protection. Or we could say we want to see the text of the International Covenant in our Constitution. But I think there are clear texts there. And And I don't think we should become too concerned about the issues that, I mean, Michael raised, for example, the 1983 amendment and Article 43.3 of the Constitution. It was in fact predicted in 1983 that that would lead to very particular difficulties with interpretation, because of course that set up two conflicting rights. So that's a very particular example. In fact, if we place in the Constitution clear text and clear guidelines for judges, then we're not going to be faced with the sort of the unpredictable or unforeseen consequences that Michael has suggested. The unintended consequence we need to look clearly at, for sure, but we can overcome that because this is not new. We are used to having rights that are enforceable in our Constitution, and we can look at other constitutions where this has been done.
Okay.
We can look at the South African one, which was introduced at a time of enormous resource difficulty after the collapse of apartheid, and which yet set out a real vision for an equal society. So I would just say, just as Ross has said, we are Carlsberg, we are the brewery here in the Constitutional Convention. We can determine the text that we want to see in our Constitution, and we can also set out the restrictions that are on that, so that it doesn't become an issue of unaffordability and so on. I think there's clear mechanisms available to us to do that. It's not a floodgate or a panacea, as Mary said, but it does give us a way to provide a step forward to a more progressive and a more equal society. Thank you.
Thanks very much, Ivana. Tom, please.
Tom Burke. Michael McDowell made the point that he asked the question, do we trust our politicians to spend, to make the spending decisions, and should we allow them to make the decision whether the money is spent on Aosdána or on, for example, housing? I would suggest that we don't trust our politicians to make those decisions in a sensible way. You have, I understand, a situation where if a person is in full-time employment, they will not get assistance from the state towards meeting mortgage costs. However, an unemployed or a person in need of housing from the social services will get a rent allowance to live in a property that has had to be vacated by somebody in full-time employment. Another one, I think we should have a programme to reduce housing lists. At the moment, the housing lists are just growing and growing and growing. And I fear for the consequences for the country if something isn't done in that respect. Thanks very much.
Okay, thank you. I'm going to take David and then Avril and Catherine later on. Okay, could we have the microphone here, please? And then I'm going to go back to the panel for some comments, okay? And again, I'm going to urge people to be brief in their contributions. David, yeah.
Yeah, what I took from Michael's contribution, if I could sum it up, I suppose, in one message that I took from it, is that, yes, you can have all of these rights, but only if I say so. And the I being the political system. And it completely misses the point that we, the people, can decide by way of a referendum, putting a formula of words into the Constitution that sets out a basic level of protection for all citizens. And that's essentially what is being argued here. I also found it was a bit patronising, the comments that we don't fully understand what's been put before us, because we had a discussion at each table here in relation to, well, what form, what method, what structure, how would you implement this? We haven't got to that stage yet. We're having that broad discussion around, is it a good thing to do? And then, of course, we have to work out the way in which you would do it. And the final point is in relation to the courts, because again this notion was put to us that, well, this gives too much power to judges and the courts. In fact, it doesn't, because it gives power to citizens to be able to take court cases. And if you follow the logic of what Michael is saying, then Louise O'Keeffe would not have had the opportunity to go to the European Court of Justice to have her rights vindicated, nor would the Waterford Crystal workers who went to the European Court of Human Rights to have their rights vindicated. The right to go to court and have your rights vindicated surely should be seen as a good thing in a functioning democracy. And the role of the courts is not to dictate to the legislator, it's to interpret what is in the Constitution, which is put there by the people. So let's have a bit of faith and a bit of trust in the people of this state to make the right decisions.
Okay, thank you. Avril, please. And then Catherine, and then Jim, and then we're going back to the panel, okay?
I too would like to pick up on the fact that one of the main points that seems to be made against is the idea that it's dangerous to give the judges any power in this context, and I think that just misses the whole point of a constitution. The reason we have a constitution is that it sets out some of our basic principles as a society, and it says that there are certain issues that we want to take out of the hands of the government of the day. There are certain principles that no matter who is in power, whether they're very left-wing or very right-wing, that we as a people feel are fundamental bottom lines. And that's the whole point of why we have a constitution, and that's why we give powers to our courts to have certain overriding protection for human rights. Because I think the reality is that, look, I'm a politician myself, but I think the reality is, unfortunately, that politics often does just represent the most powerful voices in society, the people who vote, the people who have political power, the people who can get 20,000 people standing outside Leinster House overnight when they're challenged on an issue. It doesn't often speak for people who find themselves without a home, who are sleeping on the streets of Dublin tonight on a freezing cold February night and don't have that political power to demand that something be done about homelessness. And to me, it is fundamental that no matter how poor we are, nobody should find themselves in that situation where they have their kids out on the streets of O'Connell Street or anywhere else. But I just want to go back on the key point that has been made, is that there is nowhere, and I don't think anyone in this debate is arguing that we should have absolute rights. The point was made earlier that there's no country in the world that does that. The idea is that you would have certain principles, that you would ensure that political decisions have to meet standards of reasonableness and rationality and transparency. And a key question that was asked earlier as well was, what difference would it make at the current time? And I would say that if you look back on some of the decisions that have been made in recent years, I think often what we've seen at cabinet level is that particular ministers fight for their own individual departments, that they don't think about the impact that cuts in one area will have elsewhere. And I think that some of the decisions that have been made, things like cutting resources for disadvantaged schools, or cuts in mental health services and things like that, if they were held up to a rationality test, you would show that in fact those cuts, while they save X amount this year, will cost 3 times more over the next 10 years. And I think what your court would do would be look at that and say, this is not rational, you need to relook at that. I don't think the courts would be telling the politicians what decision they need to make, but it would say, come back to us in 6 months and show us a better way of doing this, because we feel that you haven't actually thought through the consequences, you haven't thought about the cost beyond one department, you haven't thought about the fact that if somebody drops out of school, they're going to end up in the justice system, they're going to be dependent on social welfare. So I think it's just holding up political decisions to a basic level of scrutiny and reasonableness, and personally I don't think we have anything to fear from that. I think it would be a good thing.
Okay, thanks, Avril. Thank you very much. I think everyone... Catherine, please.
Thank you, Catherine Murray. On the issue of affordability, I just read very briefly in today's newspaper that if Ireland is to implement universal healthcare for all, that it will create 7 new quangos. 7. Now, I don't know how true that is, but our government that are in power at the moment said before they became elected that they would reduce the amount of quangos in this country. That hasn't happened either. So I think if the resources are used wisely and fairly, I think they would be there to implement some of the rights that we speak about here today. Thank you.
Thank you. Okay. Jim. And then maybe the last comment will be Hetty, and then we'll go to the panel. Okay?
Tá Bronarum Choctas Jockerish, Tom, but I do feel that at its core this is a simple issue of, in 1867, Benjamin Disraeli was the first to bring in the condition of the people. Before that, it was the maintenance of law and order and the defence of the realm. And in a codified constitution such as ours, it's inevitable that you're going to have some social issues, socio-economic issues put into it. Now, Disraeli brought in his condition of the people in response to the liberal laissez-faire Benthamite philosophies of the Liberal Party, which were remarkably reintroduced to Irish society in the 1990s by pernicious ideologues, and led to things such as individualisation and led to deregulation. So there is a middle ground. And I think that it would be judicious to look at some social provision, socio-economic provision in our constitution. Where I would agree with Michael McDowell is we probably should festina lenta, we should hasten slowly, but I think there is room for its consideration. And I don't think, I heard Michael mention the words don't know, 7 times in his, so I don't know whether it was a bit of a subliminal auto-suggestion, but I think the people do know and can know,
Okay.
and we can consider it.
Okay, thanks, Jim. Hetty, please.
Hetty Dewey from Cork. The point has been made that the government can make new legislation to incorporate these rights, but the government has not up to date now done anything for this. So that's why I feel it should be included in the Constitution.
Okay, thank you. Okay, I'm going to go back to the panel now, and I would like you to either respond to what you've heard from the panel or what you've heard from the floor. Okay, we start with you, Colin.
Okay. I suppose, first of all, just to try to capture some of the broad themes that I've picked up on, it does seem to me extraordinary that the opposition to this are asking us, should we not trust politicians, and telling us that we should not trust judges on some level, it appears to me, which is extraordinary. Well, actually, when it comes down to developing a legal framework through which we make really important decisions about dignity, about human dignity, about the kind of republic that we might be, about the values that we have, the people that we should trust are ourselves, because the Constitution is our Constitution. We define it as a people, and it is the framework by which governments, and indeed the judiciary, are obliged to make decisions and then to adjudicate over those particular decisions. But even more importantly, it's not about trust. The key principles here, what judiciable or what constitutionally enshrined rights would do, is demand that the governments put in place meaningful, transparent, evidence-based decision-making processes that are focused on outcomes. It should never mean that we have to trust governments or political parties to do the right thing. It should mean that we have a system in place that shows that they are required to demonstrate that they're doing the right thing, and doing the right thing on the basis of real evidence, considering the rights and needs of all people on whose behalf they govern. This is not about tying the hands of a government. This is absolutely about providing a framework that a government of integrity can use to make good, complex decisions based on evidence about what it does with our resources to meet our needs and our rights as decided and dictated by us, the people, and nobody else. So we should trust ourselves, and we should put in place a framework that allows those that we elect to govern us to demonstrate that they are worthy of that trust, above all else.
Thank you. Mary, I'm going to go to Mary next, and then after that I'm going back to Michael, and then Mike and Rossa. Okay?
Yeah, it's almost like the right to have a framework for good government. I suppose some of the accusations that what's going on is very vague and that the proposals aren't concrete enough, I think to some degree they were answered by Ivana there, but you are in the middle of a process and you are determining and making more concrete your proposals through your own process of deliberation there. It is complicated and it is challenging, but I from what I hear and the level of deliberation in the room, people have a quite good grip on the complexities that are involved, and I think you should have full confidence in yourselves that you'll be able to get a concrete proposal by the end of the deliberation. Ross has said that saying one person has a right means someone else has to pay for it, and I just think that needs to be challenged full on. It does not. Rights are in the context of available resources. It's absolutely clear that rights are framed in that, and to say that just by giving somebody a right, somebody else has to pay for it, is really misleading and to some degree dishonest, I'd have to say. I think the whole debate to some degree is about access to justice, and access to justice is a form of access to power. And there is a huge correlation, a huge overlap between economic inequality and political inequality. The poor are less likely to vote, they're less likely to participate in non-government organisations or lobbying groups. They simply have less access to power, no matter how you describe power. And I think to some degree, the Constitution allocates power, and this gives us a mechanism to rebalance power, and particularly to give some form of empowerment to the most vulnerable. And I think, you know, we owe it to people to take that seriously if we can do that. And I think, again, just to stress, it is about fundamental bottom lines. It is about a compass for the kind of society, the direction we want to set ourselves after this turmoil. And we want to set ourselves maybe in a more dignified direction with a clearer set of values that can make an economy that serves society rather than what we had for the last few decades.
Thank you, Mary. Michael?
Well, we've just had a number of suggestions as to what we are actually speaking about. And I didn't, contrary to what David said, I didn't say that this Assembly was incapable of understanding the issue. I said very simply, David, that no concrete proposal had been put to this body, and that's what I meant. And it hasn't yet. And we are discussing in the abstract, at the level of principle, something which has not, in fact, been put in concrete terms. And that's a very important issue, because if you're talking about changing the fundamental law of our society, and according to the judiciary, the right to implement that law, you better know precisely what it is you're handing to the judiciary by way of power, because you're taking it away from the discretion of the elected representatives to implement it thereafter. So that's a fact. The second thing is that Ivana Bacik says, you know, it's great. She says, you know, we need a constitution which embodies our vision and our aspirations for a society. That's what Article 45 is all about. And that's what Dev said. Those are visions, those are aspirations, but the people who implement them are politicians. That was the fundamental decision he made. And he had to give a good handoff, to use a rugby parlance, to the archbishops and say, get off our patch. I'm a Republican. I want to have a Republican constitution where these matters are decided by elected people, not by judges. The next point that I just want to make in response to what I've heard here is, you know, Ivana also said, oh, well, there were some people who saw the problems with the 1983 wording. Yes, they were. And I remember exactly one evening watching television when Professor William Binchy, the enthusiast for the pro-life amendment, derided now Mr. Justice Adrian Hardiman on television for suggesting that there could be travel injunctions if this wording was put through in its present form. So the point I'm making in relation to that is, if you come forward with a proposal, you must look around all the corners and have it absolutely debated before the people. And before you say this should be in the Constitution, it's necessary to say what exactly does it mean. Now, and for instance, you might imply from the fact that the dwelling of every citizen is inviolable that there's an anterior right to have a dwelling in the first place on the present Constitution. You might well say that, and I think probably that's a very strongly arguable point. If the citizen has a right to keep his dwelling inviolable, presumably he must have a right, or she must have a right, to have a dwelling in the first place. And the judiciary probably would be capable of persuasion that there was some right to housing in our present Constitution. But if you then say there is a right to housing in the Constitution, is it satisfied by the judiciary, for instance, saying everybody is entitled to have a room or 2 rooms, everybody is entitled to be put up in a hostel or a B&B if there's no room, or whatever? At some point, the right to housing, the right to have a home, a permanent home, which is what Mike is talking about, the exact meaning of that phrase must be determined. And surely it's for elected politicians to decide whether it means a house of your own or whatever, or a house where you want it, or a house near your job, or a house 100 miles away from your job where nobody wants to live. These are issues, surely, that elected politicians must deal with. And the last point is this: I'm not saying trust politicians. I am saying trust yourselves. And I'm saying that that what the Constitution means, and it's a Republican Constitution, I remind the Republicans here, it's a Republican Constitution. It says that the people decide through their elected representatives how to achieve the Article 45 aspirations. And that if you, for instance, are sitting down and looking at a budget, that you empower your TDs to make a decision on that budget, and you tell your government to make to come forward with the budget. And what fascinated me here is Avril Power, who's a member of the Oireachtas, suggested that the budgetary process itself should be subject to judicial review. And I believe if you just look around that corner, that people who are unhappy with the balance struck in a budget can go to court to have it redressed. What kind of society are we going to have, and what kind of judiciary are we going to elect, and on what basis are they going to be chosen in future? These are questions which it's very, very easy to say, these are the little details that we'll deal with later. They're central to the whole issue. If Avril is serious in saying that she wants the courts given the right to review the budget every year to see was it proper, did it draw up a rational and transparent. She did. You did. You said that the budgetary decisions should be subject to review.
I said that if somebody can make a coherent argument that a particular decision was fundamentally irrational,
yes,
the court should be able to look at that.
Yes, and that means that if the Association of Irish Patients say that cutbacks in the hospital service are irrational, given that they're spending X and Y on ministerial pensions, they have a right to go to court and make that case. And I do not believe that that's a road we want to go down.
Yes. That's fair. That's fair. Okay, Mike.
Okay. I think either Michael McDowell has misunderstood the process of the convention, or I have, because my understanding of that you don't have a clear proposal in front of you is because you are trying to formulate a clear proposal. Yeah. And that we're trying to help you sort of throw in some ideas, and you're going to, over your deliberations, clarify that and not come out. I think your record to date has been that you have come out with very clear proposals at the end of presumably a deliberation process very similar to this. So to get caught up with the fact that you don't have a clear proposal in front of you at the moment is because that's what you're doing, is formulating a clear proposal, and you will go through the number of options that are available to you before you put that forward. In any case, you're not going to change the Constitution. You're only going to put forward an idea which the people are then going to discuss if we get that far. And it's the people that are missing from what we've listened. Like, it's this, do you trust the politicians or do you trust the judges? Or what a depressing question. Because that is the problem that somebody's missing from Michael McDowell's Republic. And it is the people. Because I don't think a republic is a place where we elect a government and then throw them out. It is a place where the people are sovereign. And one of the ways they're sovereign is by electing public representatives and throwing them out if they do the wrong thing. And the other way is by setting the framework, the values and the constitution by which we do this. And the reason most common law countries don't do this sort of thing is because they don't have citizens, they have subjects. We are a republic. And so we have the opportunity to look at our common law in a different way and start putting rights in as citizens in the way we do it. Of the 19 countries that have in their constitution a right to housing, 2 are common law. So it is possible. Of the 20 countries that have in their constitution general rules about a right to housing, 4 are common law countries. So it can be done by those who wish to push it out. The central argument that Michael McDowell and those against this are making is basically that the Constitution is not the place for things like this, right? Now, where we sit in terms of representing people who are in danger of losing their home or trying to get back into a home is about the price of things, it is about resources, it's about who owns the unit of the house that they want to move into, and what rights they have vis-a-vis the person who's trying to get in there. And that's not just about people, we now know that's not just about poor people and better off people, it's about if the bank owns your home, that they are the property owner. And the constant problem in trying to form this balance in the Irish context is there is a right to property in the Constitution, but there is not a right to a home. So in any conflict in front of the court see the right to property above the right to a home. That's a value question. The place I live is property, but it is also my home. And unless we have some way of balancing that, if Michael McDowell and those in that position want to follow to the logic of their argument, there should be something on your ballot paper that says take the right to property out of the Constitution. I wouldn't propose it because I don't think it would get through, but you have to remember that it's there and it stands against my right to a home. He says that the right to home may already be there. And if I employ a really clever chap like him, if I had the money, he would be able to argue that such a right actually is there. Well, if it is there, wouldn't it be much more simple to put it in front of people, to put it there clearly, so that we don't have to constantly use expensive lawyers to explain what the Constitution really means, and put it clearly there in an absolute way so that we know where we stand, and the elected people, our public representatives, are people who deliver our public services, and our citizens know what we want to be delivered and are able to judge whether it's actually being delivered.
Mike, thank you very much. Rossa, and you have the same amount of time as Mike just had to maybe conclude this session.
Thank you indeed. Well, Chairman, being broadly opposed as I am actually to the further incorporation of socio-economic rights into our Constitution, I do appreciate that perhaps guarantees me the warmth of welcome normally reserved for Woody Allen at family reunions. But I do find myself, notwithstanding that low expectation, slightly reeling from Mary's broadside against what I thought was a fairly uncontroversial proposition. And that was the proposition that if you have the right to something that costs money, somebody must pay for that, such as a textbook. I really don't see what's controversial, misleading, much less dishonest about that proposition. My simple proposition to you is this: constitutions aren't the proper place for contemporary political fashion statements. Constitutions as a type of document are supposed to be permanent statements of fundamental values. And it is not appropriate to deal in constitutions with broad concepts that in fact have to be understood in granular detail. And if you say that somebody has a constitutional right to housing, what does that actually mean? Does it mean housing of a particular square footage? Does it mean shared housing? Does it mean a B&B? Does it mean a hostel? And what about the more complex problems that actually underlie the homelessness situation of a particular individual? Is that person somebody who has been rejected from a number of shelters or hostels because they're a persistent user of drugs, or they're schizophrenic or something of that sort? There are very real and complicated problems that underlie each individual homeless person's situation on the streets. And it is not the case that a broad sweeping inclusion of a constitutional protection can somehow give the courts an answer to what that right means in the case of each individual person who won't abide by the house rules of a hostel in which they previously were accommodated. Constitutions don't contain granular detail, and courts are not the best place to determine granular detail. And in conclusion, I will come back on a point that Ivana Bacik made at the very beginning of the contributions from the floor. And she said all we need in the Constitution is overarching detail, and we don't get involved, in essence, in the nitty-gritty when you talk about the right to education of an autistic child. But that's precisely what happened in the 100 cases that followed Sinnott. Parents brought cases on behalf of their children, seeking mandatory injunctions against the state, compelling the state to provide perhaps 20 one-on-one speech therapy hours per week at an enormous cost. And the state would counter that with an offer of 10 hours. And you'd have two experts in treating the conditions of autistic children giving evidence, and the High Court judge would have to determine. And the case might be settled on the basis of 15 hours. Now, if you think that's an appropriate way in which decision-making is made as to the allocation of resources for sensitive problems on a case-by-case basis, I have to say, I think, as a body, you're incorrect. Ironically, it's the two lawyers who find themselves in a situation where we're saying, leave that material outside the courts. It would be in the self-interest of the legal profession, it would have to be acknowledged. If all of these complicated issues would come down to the courts, we'd never be out of work as a class of people for decades to come. But it seems to us, I think, that complex policy decisions of this type are better dealt with by specialists rather than judges, who themselves, ironically, have said in the TD decision and in the Sinnott decision that they are not the best arbiters of complex issues such as these.
Okay, thank you very much. No, I'm not going to take any more contributions from the floor because we are actually up to our time, but I just want to thank the people on both sides Colin, Mary and Mike, Michael and Rossa for their contributions, and I hope you've been enlightened by them.